As a business owner, you might find yourself in the unfortunate situation of having being separated from your spouse or your de facto partner. You might then ask yourself, well, I've got a successful business, what's going to happen to this business? Will my spouse or de facto partner take all of that business? Will I be able to retain that business? Will my spouse or de facto partner have a share in that business? So in family law, one of the first things that we need to consider is what are the assets, what are the liabilities, and as well as what are the financial resources. So clearly a business is an asset and that will form part of the pool. Now, we've included the business in the asset pool, but we also then need to ascribe a value to that business. So then you might ask, well, how are we going to value the business that we have? There are various methods of valuing businesses, and this is where we as family lawyers tend to engage expert valuers that deal with valuing businesses for family law purposes. So one of the methods, for example, is future maintainable earnings, and also another method of valuing a business is the net tangible assets, or the underlying assets of the business. So that could be real property, that could be shares, that could be plant and equipment. So all of those assets would need to be valued, either collectively or individually. Once we provide the report to you, you might have a look at that report, and then you might turn around and say, well, you know, hang on a second, I don't actually agree with this value. You know, it's been overinflated. In that particular circumstance, we'll probably advise you to obtain what we call a shadow expert to provide their own expert opinion as to what the value of that business is. Once the value of the business is established, now that can be either via agreement between the parties, depending on what the reports say, or it could also be depending on what the court determines, if it happens that the matter has to go all the way to trial. So as I said previously, that value will be included in the asset pool, and it will be divided amongst the parties. If as part of your property settlement you want to retain your business because you've been running it since establishment, or you've taken that over, then that can be put on your side for you to retain as part of the overall split that you will have with your spouse or your de facto partner. One of the most important things in terms of family law is that you actually formalise an agreement. So that can be either via consent orders, that can be done either via a financial agreement, for the relationship, during the relationship, but it also can be after separation. And if in the unfortunate circumstance parties can't agree, then it can be via a trial and the court determining how the property is to be split. If as part of your property settlement you wish to retain the business, then I strongly suggest that you formalise that agreement. That can be done either via consent orders, that can be done also via financial agreement. Once you have formalised an agreement with your spouse or your de facto partner, you are then in a position to deal with that business or any other asset that you've retained as part of your overall split in whichever way you please.